Assalamualaikum and good morning, Mr. Zainal.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you so much for reaching out to us. We know that you made an appointment today with us to discuss on specific matters regarding your problem and so on. So, as you can see, we are still living in the pandemic, and it means that we cannot conduct our session physically. So, we just proceed our session through online. I hope you are okay with that. Before going any further, let me introduce myself first. I am Afrina. I am the assistant for the counseling session today, and here is the senior counsel Raja and his co-counsel Aina. We will work together to give you on advice on some possible legal and non-legal solution to your problems, but it is completely your choice to decide on what you think the best for you.
We would like to get to know further about yourself. So, can you briefly introduce yourself and any other thing if you want to?
Sure, so let me introduce myself. My name is Zainal. I have a problem that needs to be addressed, and I have heard great things about your legal firm, and therefore I would like to consult with your firm. I'm fine with this online consultation actually, but I'm a little bit upset that we won't be able to meet in person.
So, are you okay if we call you Mr. Zainal?
Yes, yes, I have no problem with that.
Alright, Mr. Zainal, for your information, our discussion and conversation today are confidential, so just feel free to tell us everything and anything you want. We can review your information and try to help you out without you worrying about this information getting out.
Okay, I got it.
I need to ask you at this stage whether you have received any legal advice on this matter which you are coming today.
No, this is the first law firm I consulted to.
All right.
Before we go further, I would like to inform you that throughout our session today, we will be mentioning the word like plaintiff, respondent, or defendant. So these words are not referring to you. It's just an example, just to make sure our explanation clearer. If you have any problem in understanding our discussion today, so feel free to ask. Okay.
Sure, no problem.
Okay, we will start now. First, we would like you to describe what happened in your situation and please feel comfortable telling us.
Okay, at that night when I was cycling, I spotted a speedy SUV. The driver seemed to exceed the speed limit that night. She lost control of the SUV while turning on flyover and subsequently collided with me, who was cycling on the side of the road.
Then what happened after the driver hit you?
Unfortunately, I sprained my ankle severely. The driver, though, was not seriously injured, but the SUV was crumpled. I was rushed to the hospital by ambulance, where a doctor taped up my ankle and gave me a crutches. The doctor also prescribed for 12 weeks of physical therapy.
Because of the treatment, does it affect your daily life?
It does indeed. Because of the sprain, I won't be able to start my new home business for another 4 months. I'm very frustrated with this condition as I can't walk or work like I used to. And I believe that I have right to Surana in order to claim for compensation because she has caused me so much pain.
Alright, Mr. Zainal, thank you for your cooperation for informing us about the situation. May I know what do you expect from us and what kind of advice do you want to hear from us?
I am very happy about this condition and would like to consult regarding this matter so that I know what I am entitled to in order to file a claim for compensation. But first, could you maybe provide me with a brief explanation of damages related with the injuries I suffered?
Alright, sure, Mr. Zainal, but I'm sorry, you mean that you are very unhappy, right?
Yes.
Okay. We are delighted to help you, of course. So, firstly, I will explain to you about damages, and my other colleagues will focus on your rights and damages that you can claim to recover the loss. Can we do that?
Right, sure, thank you.
Okay. So first and foremost, damages in law refers to money compensation for loss or injury caused by the wrongful act of another. And I am pretty sure that you are informed about this matter since you came here to know about damages in general. However, I wish that you were also informed that the topic of damages is actually quite big. So our discussion today will be focusing only on damages for personal injuries since it is the reason why we are here today. So let's dive into it. Damages has two types. First is pecuniary loss and second is non-pecuniary loss. We will focus on the second type, which is non-pecuniary loss, because
Pardon, but what exactly are pecuniary and non-pecuniary losses? I'm actually very interested to know more about general damages, since I have made my reading before this.
oh yeah, actually we will go deeper on that after this, but that's okay. I will explain to you now. Pecuniary loss is losses that we can calculate precisely, and it is also called special damages. It must be specifically pleaded in the statement of claim with full details. For example, when it comes to medical cases, you must have all the bills. And you must know that it is recoverable only when they can be included in the proper measure of damages and are not too remote. While non-pecuniary loss is losses that we cannot precisely calculate in exact monetary terms, and we call this as general damages. The area is quite big, so let's focus only on our specific discussion today. The thing that you need to know about general damages is it can be claimed whether it is before or after trial, because the plaintiff could not precisely calculate in exact monetary terms, for example, pain and suffering. And then for pecuniary loss, it comprises loss of earning, out of pocket expenses, and damage to personal items or property. While for the non pecuniary losses, there are basically four types under general damages, which are first, pain and suffering and loss of amenities, second, loss of consortium by husband or wife, third, loss of future earnings, and lastly is loss of earning capacity. Since you are very interested about general damages or non-pecuniary losses, let's dig into it.
How can the court estimate the damages when we could not know the number of losses from it? For instance, you have said before that we could claim for pain and suffering.
Yes, of course. The pain suffered cannot be measured in financial terms. Neither could the court assess logically the monetary value to the damage. So, for that, the court will take a fair and reasonable compensation for the injury suffered. For the first type, which is pain and suffering and loss of amenities, this type of damages actually consists of three parts, which are first, pain and suffering, second, loss of amenities, and third, mental anguish caused by awareness of shortened life expectancy. For the first part, which is pain and suffering, I would like to explain further by referring to the case of Shan Mugam anak lelaki Gopal and Zinal Abidin Nazim. What happened in this case is the first trial court, which is session court, did not award the plaintiff for pain and suffering for a future operation that the plaintiff had to undergo. And then the appeal court judge later found that the plaintiff suffered fractures to his right thigh and leg and his right hand. He needed to undergo a future operation to heal these injuries. Due to that, the plaintiff also had to always go to the hospital as the effect of from the operation. The court awarded the court awarded damages for the plaintiff for pain and suffering, although the operation will be conducted in the future. And then for the second part, which is loss of amenities, loss of amenities occurs when the plaintiff's injury has deprived him or her of enjoyment of life. The court will consider the plaintiff's age, marital status, social or business position, and deprivation of money value and other relevant circumstances. So the case related to loss of amenities is the case of Tai Tong Chiu and Abdul Rahman. What happened in this case is the respondent suffered dislocation of his left hip and closed fractures of his left, resulting a 5 cm shortening. Due to that, he could not fully squat, run, cross leg, tie his shoelaces, nor cut his toenails. So then the court awarded RM 40,000 ringgit for pain and suffering and loss of amenities. Because the plaintiff was once an active sportsman. He was a swimmer and played rugby for his school, and now he cannot do gymnastic, tie his shoelaces, cut his toenails, and has difficulty in driving a motor car. And then for the last part, under pain and suffering and loss of amenities, is mental anguish caused by awareness of shortened life expectancy. So I would like to refer you to section 28A, subsection 2, paragraph B of Civil Law Act 1956, which it provides that in assessing damages relating to pain and suffering and loss of amenities caused by the injury, the court shall my apologies, Mr. Zainal. The court shall take into account the mental anguish caused by him by his awareness that there is a reduction in his expectation of life. So the case related to this is an English case, Flynn and Lovell. So in this case, the court awarded a 69 years old plaintiff separate damages for mental suffering caused by his awareness has caused him to suffer shortened life expectancy, which is loss of expectation of life. Uh, all right. For now, Mr. Zainal, are you okay with my explanation?
Sure, okay.
Okay. So next, under general damages is loss of consortium by husband or wife. This refers to the deprivation of the benefits of a family relationship due to injuries caused by a tortfeasor, as decided in the case of Basmini Muhibah Sendirian Berhad and Abdullah bin Salim. Uh, the respondent's wife in this case involved in an accident which resulting her to suffer mental and physical injuries, and then the husband complained that his wife had recoiled from his physical and moral companionship, and after the accident she has changed and no longer in a position to give him the comfort and care she once gave her husband. He had lost. In this case, this man has considered to lose his consortium, and then the court awarded damages for RM 3,000 ringgit as general damages for loss of consortium. This kind of loss also what we can call a damage, so you can claim from it. Okay. So for now is the third type of damage, which is loss of future earnings, where one can claim for it if the injury he suffered causes him to be unable to work for some time, so after the trial or for the rest of his life. So it is the case related to this type of loss is Sam Woon Hong and Kadir Ibrahim Shah. My apologies. So the plaintiff in this case has lost his right leg from the road accident, and then the High Court awarded him damages for pain and suffering, but refuses award for the loss of future earnings. And then he appealed, and then the Federal Court upheld the decision of the High Court in finding that there was insufficient evidence to give an award for loss of future earnings. The court found that the applicant was still doing and could continue his work as an estate contractor, the same business before the accident, and then the evidence showed he was capable of supervising the work and giving instruction to his workers. So, Mr. Zainal, to put it in easy way, you cannot be awarded for loss of future earnings if the injuries you suffered didn't cause you to be unable to work. Do you
Okay, now
understand? Okay.
now I understand. Are there any specific ways to calculate the damages related to loss of future earnings since it involves our wages, right?
Yes, of course. In calculating damages for loss of future earnings, it was decided in Tan Kim Chuan and Chandu Nair Anak Lelaki Krishanan Nair that Section 28A of the Civil Act 1956, which read damages in respect of personal injuries, is mandatory. And I wish to first explain about Section 28A subsection 2 of Civil Law Act 1956, which states that in awarding damages for loss of future earning, the court shall take into account first, if the plaintiff is 60 years old or above, no damages for him, unless the plaintiff was receiving earnings by his own labor or other gainful activity before he was injured. That's the first one. And then for the second one, only the amount relating to his earnings as aforesaid at the time when he was injured and not any prospect of the earnings. And then third, any diminution of any such amount as aforesaid by such sum as is proved or admitted to be the living expenses of the plaintiff at the time when he was injured. So the court will calculate the damages for loss of future earnings according to the laws that we have. There are two parts. First is multiplier and second is multiplicand. And I don't wish to go further on this. We will just discuss about the general matters under this calculation of loss of future earnings. So the first one is multiplier. We rely on Section 28A, subsection 2, paragraph D of Civil Law Act 1956, and it states that for any plaintiff which age 30 years old or below, the multiplier shall be 16. And if the plaintiff is 31 to 59 years old, the multiplier follows a special formula. This is only the general about multiplier, okay? Okay, and then for the second one, which is multiplicand, it stated under section 28A subsection 2 paragraph C, which is no damages for the plaintiff unless first the plaintiff was in good health, and second the plaintiff was receiving earnings by his own labor or other gainful activity. And also the court shall not take into account any increment salary. Okay. Uh, okay, so now is it clear, Mr. Zainal?
Yes, yes.
Okay, now the last one, which is loss of earning capacity. So what does it mean? It is actually a reduction in any person's ability to earn an income due to a personal injury. This situation usually arises when the injury is severe and causes the victim to become disabled or to have to go into a different line of work. There are basically four senses in claiming for this loss. The first sense is where the court is satisfied that there is a real and substantial risk that the plaintiff will lose his job or get less paying job because of the injuries. For the second sense, where there is no satisfactory evidence but it is satisfied that the plaintiff has suffered a loss of earning capacity. And then for the third sense, where the plaintiff was too young to have earned everything. And the fourth and the last sense is where the plaintiff must be receiving earning by his own labor or other gainful activity before he was injured. This one is stated under Section 28, subsection 2, paragraph C of the Civil Law Act 1956. So, another type of loss under loss of earning capacity is loss of earning for the lost years. The lost years here refers to those years of life expectancy to the plaintiff through the tort of the defendant. So the case related to this type of loss is Pickett and British Rail Engineering Limited. This is an English case. So what happened in this case is the plaintiff sued his employer claiming damages for personal injury. His life was reduced to 1 year from the date of trial. And then the trial judge awarded him a sum for loss of earnings for the 1 year period or likely survival. He appealed, but then he died before hearing. His widow substituted him as the plaintiff. And then the House of Lords allowed the appeal, and the plaintiff was entitled to damages for the whole period of the plaintiff's pre-accident expectancy of earning capacity, less his own living expenses. Another thing that you should know under this laws is it is stated under Section 28A, subsection 2 of the same Act, which states that in assessing damages under this section, first, no damages shall be recoverable in respect of any loss of expectation of life caused to the plaintiff by the injury. And then second, if the plaintiff's expectation of life has been reduced by the injury, the court in assessing the damages shall take into account any suffering caused or likely to be caused by awareness that his expectation of life has been reduced. So, are you okay with that? So far, do you understand, Mr. Zainal?
Yes, aren't these just about general damages? What about special damages? And which one and am I entitled to?
Yes, Mr. Zainer, you are right. It is only about general damages. For special damages, my colleague, especially Raja, will explain about this since it relates to your situation. Thank you.
Okay. Okay, so who can I sue for my injury? Can I sue Rana as she was the one who had drove negligently?
To answer this question, you must have proof that there is a link between the act of the wrongdoer and the damage caused to you. In this case, specifically, you must prove that the defendant's breach of duty has factually caused you to suffer injuries.
I'm sorry, but what is the factual causation?
It's okay, let me explain it to you. In an action for negligence, the plaintiff has to prove that the defendant's act was the effective cause for the injury suffered by the plaintiff. Simply speaking, for factual causation, you can sue the one who caused your ankle to be severely sprained.
Oh, now I understand a little bit. So, what can I do to prove that Rana's act is the factual causation for the injury that I suffered?
Well, in this situation, we can apply for the but for test to the person who had drove negligently, which is Rana.
But for tests, I have never heard of that. Can you explain more about that?
Yes, sure. To put it in easy manner, the but for test is the question that one will ask himself: if that person did not commit that particular act of negligence, would the victim still suffer any damage? So, in your situation, the question here would be: would you suffer any damage if Rana did not drive negligently? Do you understand my explanation?
Yes, of course. Thank you for your explanation.
Okay, and now I will refer to some cases to support our claim. So, in the in the case of Siti Atira binti Muhammad Safwan and Razanatul Ain bin Hassan, in this case, the appellant was riding her motorcycle when suddenly a car from the opposite direction, driven by the first respondent without any signal, turned into her path. The car was heading for a junction that was on the appellant's left. The appellant was unable to avoid the first respondent's car, and the car collided with the appellant's motorcycle. As a result, appellant suffered extensive injuries. The court held that the first respondent failed to exercise her duty as a reasonable driver to prevent harm to other users by not giving a signal before turning. In this case, the accident which caused appellant to suffer injuries would not happen if the first respondent had driven responsibly by giving signal before turning. So, by looking at your case, on the defendant's way to get home, she drove over the speed limit. So while making a corner on the flyover, she lost control of the SUV and collided with you. So applying for the but for test, the accident would not have happened if Rana had acted as a computer road user by driving below the speed limit and do not overspeed. By doing so, she would not lose control of the car when making a turnover and thus will not collide with Zainal. It will not collide with. So, in conclusion, the negligent driving of Rana by driving above the speed limit has factually caused you to suffer injuries.
So, does that mean that the person who I can sue for my injury is Rana?
Yes, that's right.
Okay, but what can I claim from Rana?
All right. First, you had to spend a lot of money to pay for the bills for hospital treatment and care, right?
Yes, first I have to pay for the ambulance fee, then I have to pay for the cost of treatment by the doctor for my injured ankle, and I also need to pay for the cost of attending the physical therapy, and finally I also need to pay for the cost of using the crutches.
All right. So you can claim for that under out-of-pocket expenses.
But what is out of pocket expenses?
Here, let me explain. Out-of-pocket expenses is the money that the plaintiff have to expend because of the negligence of the defendant. For example, the medical expenses.
Okay, now I understand. Thank you.
All right, glad you understand that. So, in order to succeed under this claim, the plaintiff must show that the particular item of expenses was reasonable. So, in the case of Adventist Hospital and Clinic Services M and Ki Bun Swan, a 12 years old was suffering from a slightly crooked spine. Her parents then went to Dr. Cho and requested him to treat his spine. Dr. Cho recommended surgery and the parents agreed. Dr. Cho then asked Dr. Wong to assist him on the surgery and he agreed. During the surgery, they did not use the spinal cord monitoring device, which is a normal practice for such surgery. After the surgery, the girl's condition rapidly deteriorated and she became quadriplegic. The court held that the plaintiff is entitled to claim damages. Some of the damages are the cost of future treatment and the cost of physio and massage therapy.
Sorry for interrupting, but can you tell me what can be considered as medical expenses?
Sure. According to the other case of Siti Amirah binti Muhammad Safwan and Razanatul Ain bin Hassan, the court held that the medical expenses include fees for medical advice, fees for surgical operation, the cost of treatment and care in hospital, the cost of surgical appliances, and the cost of drugs and other prescriptions. And in the other case of Kasrin binti Kasmani and the official administrator, the court held that the medical expenses also include the use of special equipment like wheelchairs, artificial limbs, special artificial limbs, and medical aid. So, looking back at your case, the injuries suffered by you as a result from the negligence of the third twister, consequently making you have to receive a treatment on your ankle and a crutch, and prescribed 12 weeks of physical therapy. In addition, he also has given a ride by the ambulance to the hospital. So, you have suffered loss by out-of-pocket expenses since you have to expend money on the cost of hospital treatment and care, which is the treatment on your ankle, 12 weeks of physical therapy, and ambulance ride. Furthermore, you also had to expend money for the use of special equipment, which is the crutch you have received from the hospital. So, in conclusion, you can claim for out-of-pocket expenses in terms of cost of hospital treatment and care. That is for the ambulance fee, treatment by the doctor, and for the physical therapy. Additionally, you can also claim for the use of special equipment, which is for the use of crutches.
All right, Mr. Raja, thank you so much for your advice.
No problem.
Are there any other damages that I can claim for Rana?
For that part, Miss Aina will explain it in detail to you.
All right.
As I heard the discussion between you and Mr. Raja, that you asked whether there is another damages that you can claim for the delay in opening your new home business, right?
Yes, I want a compensation for not being able to work properly that leads to the 4 months delay in opening my new home business. In fact, I don't have any income to cover all the losses.
Well, there is another damages called as loss of future earning under the general damages.
Will you explain in detail?
Yes, I will. The loss of future earning is awarded by the court to those who are suffering injury as a result of damage made by the defendant, in which this kind of damage has led the plaintiff to be unable to work for some time or even for the rest of his life. However, there is a limitation or proof that the plaintiff has to present or establish in order to claim for the damages and the loss of future earnings.
What kind of proof do I have to establish?
Well, under the loss of future earnings, the plaintiff must prove that he or she is actually earning at the time of the injury and not in the age of 60 years old or above. This is according to the section 28A, subsection 2, paragraph C, subparagraph 1 of Civil Law Act 1956, which affirmed that where in the case of a plaintiff who has attained the age of 60 years or above at the time when he was injured, no damages for such loss shall be awarded. And in any other cases, damages for such loss shall not be awarded unless it is proved or admitted that the plaintiff was receiving earnings by his own labour or other gainful activity before he was injured. As we can see, the age of 60 years old is a retirement age. That's why the court shall not award the damages to the plaintiff who has attained the age of 60. However, if the plaintiff able to prove that he or she is earning by his own labor or other gainful activity, then he is entitled to the damages under loss of future earning. And also, as I said earlier, the plaintiff must prove that at the time of the injury, he or she must prove that he was earning, which means that the plaintiff must be already employed. For example, like working and having a monthly income. If there is no proof of earning, then the plaintiff cannot claim for damages.
If there any other authority that will affirm your statement?
Well, yes, there is a case to support my statement where in the case of Dikja Petanila Halma and Muhammad Nur Baharum, where in this case, the appellant, a qualified and registered nurse, met an accident while cycling towards Ipoh. She suffered serious injuries including spinal fracture with paralysis of the lower limbs, bladder and bowel functions. She claimed for the loss of future earnings under section 28A, subsection 2, paragraph C. In this case, the court held that the plaintiff is not entitled to the damages under loss of future earnings since at the time of the accident she was on unpaid leave.
But Miss Aina, I am 35 years old and about to open a new home business. Then I believe that I still can claim the damages under loss of future earnings to me, right?
Let me explain you further, Mrs. Zainal. However, under the same provision, it is stated that the court shall not be awarded the damages under loss of future earnings unless it is proved or admitted that the plaintiff was in a good health before the injury.
What does that mean? Can you explain it?
Alright, here the provision provided that the plaintiff cannot claim any damages under loss of future earning if she is not in a good health before involving in an accident.
Sorry, but I still don't get it. Can you explain it more?
Sure. Here, the terms good health refers to the plaintiff where before he is not involved in an accident. They were actually before the accident, they were actually in a good health and not suffer any health complications. Thus, those who are in good health without any health complications, but due to an accident, he or she become ill, then they are entitled to the damages. This was decided in the case of Osman Effendi Mahmud and Muhammad Nur Khamis, where the plaintiff was gainfully employed before the accident. His claim for the loss of future earning is direct attributable to the injury sustained from the accident. Hence, the court held that the plaintiff was having a good health before the accident since there is no medical proof to say that the plaintiff suffering any illnesses, and he also entitled to the loss of future earnings.
Okay, now I understand. But what about the money I lost due to the 4 months delay in opening my business? Can I claim for it?
Actually, Mrs. Zaina, I am afraid you cannot claim damages under loss of future earnings in order to recover all of the losses due to your injury which led to 4 months delay in opening your new home business.
But why I cannot claim for that?
Like this, Mrs. Zainal. At the time you are cycling, you are already in a good health. It is impossible for someone who has illnesses to be able cycling at a side road finely. So based on the case of Osman Effendi Mahmud and Muhammad Nur Khamis, you still have a good health before the accident. However, Mrs. Zainal, you still cannot claim damages under loss of future earnings since you are not employed and about to open a new home business. You are just started to open a business. It is based on the case of Dikja and Patanullah Halma and Muhammad Nur Baharum, where the court decided that any person who are unemployed are not entitled to the damages under loss of future earnings. This is similar to the section 28A, subsection 2, paragraph C, subparagraph 1. You have to prove that you are already gain income or employed at the time you are involved in an accident. But the fact that you are unemployed and about to open a new home business is actually have become an obstacle for you to claim for damages under the loss of future earnings. Thus, Mr. Saina, I'm so sorry, you cannot claim for damages under loss of future earnings since you are not gaining any income and unemployed.
I see. If that's the case, so I cannot be able to claim for damages to recover back from the 4 months delay in opening my new home business.
Yes. So, is there any other part that you are not clear?
I think for now, all of you have done a great job in helping me to understand. Thank you so much. Now I know what I can claim for.
All right, Mr. Zainal. So if you have no further question, our counseling session ends here. Feel free to make any consideration on the advice we have provided you with, and just call us if there are further discussions you wish to have with us.
Yes, Mr. Zainal, feel free to do so. We are here to help you. See you on the other day to plan on several matters, especially if you wish to bring your claim to the court.
Alright, I will call your firm back when I have made my decision.
Yes, sure. So with that, let's end our meeting here. Thank you, Mrs. Zaina. We wish the best for you, especially for your health, and have a good day.
Thank you.